3 weaknesses most debt collectors have. This is how you beat them in court. Brought to you by YourLegalLegUp.com, your advantage if you are being sued by debt collectors. As we've often pointed out, debt buyers who are debt collectors under the FDCPA purchase debts in large quantities. They buy them for very small amounts of money, and they bring lawsuits in bulk. These practices create weaknesses that ordinary people can use to beat the debt collectors, and in this video we discuss 3 weaknesses that most debt collectors have. You can use them to win in court. We start with the bill of sale or the chain of title. So let's get this straight. When debt collectors legitimately buy a debt, they step into the seller's shoes. That means they can sue you if the person who sold them the debt could have done so. Essential to that right, however, is that it be a legitimate purchase from someone with a legitimate right to sell the debt. And that is shown by the chain of title. It's the plaintiff's burden of proof to show that. The chain of title is shown by a set of bills of sale that must link each sale all the way back to the original creditor. In other words, if I say I bought the debt from Bob, but Sue was the original creditor, I must also show that Bob actually purchased the debt from Sue. In other words, I've not shown that otherwise I've not shown that Bob had the right to sell the debt. Most debt collectors cannot show a complete chain of title. What they tend to show is a bill of sale that says something like this. Bank sells $42 million of accounts to debt buyer, including all the accounts listed in Exhibit A attached. And then they almost never attach Exhibit A, which immediately breaks the chain of title because the bill of sale is not in any way linked to your specific account. If they do attach Exhibit A for their purchase, which they rarely do, but if they do attach it, but they purchase the debt from another debt buyer, they almost never attach all the necessary information regarding the prior purchase. I don't know why they don't do it, but the fact is that they do not, and it appears that for some reason they cannot. And that's a fatal weakness if you know how to make the argument. Business records and hearsay. Statements that are made out of court are considered hearsay as to their truth. In other words, if Bob says, Sue told me she really owns that debt, Bob's testimony would be hearsay as to whether Sue owns the debt. Hearsay is usually not allowed into evidence. There is an exception to the hearsay rule for business records. Someone who knows how records were kept, and if they were kept in particular ways which will be enumerated by the rules of evidence or possibly by your rules of civil procedure, can testify to the legitimacy of the records. This authenticates them as reliable evidence. That's what it's called, authentication. That is why most debt collectors at some point in almost every case use an affidavit by some person they hire that says, I am the custodian of records at debt collector. I know how the records were generated. They were generated in such and such ways, etc., etc. And then they claim records that they got from someone else are their business records, but the collector's record keeper does not know and cannot legitimately testify or authenticate the business records of another business. In my opinion, anytime such an affidavit is used, it's a violation of the FDCPA because it's an attempt to deceive the debtor and the court into overlooking the absence of evidence. More than that, because no lawyer could truly be confused about that, the use of such an affidavit should be considered unethical. It is flatly, plainly, and indisputably dishonest. But I'm not aware of a single instance in which a lawyer playing that dirty trick has ever been punished. Still, most courts will not accept such affidavits as evidence if you know how to object and make the argument. Sometimes, in an attempt to avoid the hearsay problem, the debt collector will use an affidavit from the original creditor, and they usually do this with their own records too, where they have their record keeper testify after all the stuff, authenticating the records, that the records show something, that the defendant owes $10,000 or some other amount of money. This statement, however, is not legitimate evidence. The business records exception is a rule that allows the business's records to come into evidence. Thus, after proper authentication, the records are allowed to be seen by the judge or jury, And the judge or jury gets to look at the records and decide what they say and how much to believe them. The records themselves are allowed to testify in court, you might say. The statement by the debt collector about what the records supposedly show is still hearsay and should be kept out of evidence if you know how to make the argument. No contract. Debt defendants like to argue that debt collectors don't have the original contract. And debt collectors love to say that they don't have to have the original contract. They say all they have to show is the use of the card. But that's all really just missing the point. Here's the underlying law. When a credit card company issues a card, it is extending a line of credit to the consumer. When the consumer uses the card, he or she is agreeing to pay the money back at the time of use. So proving use of the card is proving the existence of the contract. Check. That's what the debt collectors say. But it doesn't show the terms of the contract. Without those terms, any interest or fees that would be completely unsupported by the evidence. And seeking interest or fees without a contract is a violation of the FDCPA. And when I say without a contract, I mean a specific provision in the contract, and that's going to be where? In the original agreement, that explicitly allows for the charge of fees or interest. A statement claiming that you owe money is also not necessarily proof that you used the card either. A statement is often just a sort of balance sheet of what the bank says it owes you, says that they think you owe, I should say. And a lot of times in debt collection cases, they attach statements or they create statements made from records that were supposedly kept late in the life of the account, often at the time of charge-off. They don't show any use of the card, in other words. And without more, its mere existence is not proof that you used the card. In these days of identity theft, such statements should not be accepted as proof of anything by themselves. These facts leave holes in the debt collector's argument large enough to drive a truck through, if you know how to make the argument. The typical debt collector's case is full of weaknesses. Finding them, showing them to the court, and proving that they defeat the debt collector's case is something you can do. Helping people do that is what we do. Protect what's yours and don't let the debt collectors rip you off. Debt collection is a social justice issue. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe, and comment, as all these things help others find our materials. YourLegalLegUp.com